Welcome to The Debate. Today, we're focusing on, one of the most critical and frankly enduring philosophical splits in American constitutional law: how we interpret the Eighth Amendment's prohibition on cruel and unusual punishments.
Right. And the stakes here are immense, determining everything from sentencing rules for juveniles all the way to the continued viability of the death penalty itself.
Exactly. So, our central question is this: must the Eighth Amendment's meaning be interpreted as fixed by its original historical understanding, back in 1791, or must it evolve according to contemporary standards of decency to remain, applicable in a modern society? I'll be arguing for the necessity of this evolutionary approach, focusing on the principle of proportionality to define constitutional limits on state power.
And I come at this from a fundamentally different perspective. My position is that judicial interpretation must be strictly anchored in the original understanding of the Cruel and Unusual Punishments Clause. This originalist grounding isn't just an academic exercise. It is essential for limiting judicial subjectivity and, crucially, for maintaining the separation of powers by deferring to the legislative branch, the branch that is ultimately, as it's been said, fortified by presumptions of right and legality when it sets criminal sanctions.
Well, if we accept the idea that the Eighth Amendment is fixed solely to the standards of 1791, when methods like, flogging and branding are entirely commonplace and legal, the clause essentially becomes a relic, a dead letter. As a maturing society, we've largely abandoned those, frankly, barbaric modes of punishment. So what's left for the Eighth Amendment to police? The Supreme Court answered this pretty definitively, I think, in Trop v. Dulles back in 1958, holding that the amendment must draw its meaning from the evolving standards of decency that mark the progress of a maturing society. The goal here isn't merely to outlaw torture. It is to ensure punishment isn't grossly excessive in relation to the crime committed. This evolutionary approach is, it's indispensable for proportionality, which has been the constitutional shield used to establish categorical rules, particularly in the developmentally based rulings that restrict the death penalty and mandatory life without parole for juveniles, all resting on that foundational principle that children are different.
I see why you feel the need to use the clause to enforce proportionality. I do. But I just don't buy that the answer to preventing the clause from becoming a dead letter is granting the federal judiciary the power to strike down virtually any sentence fixed by a state legislature. The constraint we must prioritize isn't preventing legislative overreach, but preventing judicial overreach. Historically, the purpose of the clause was narrow: to bar barbaric methods of punishment, akin to torture, consistent with the English Bill of Rights context in which it was drafted. If the framers had intended the clause to give judges the power to determine the appropriate length of non-capital sentences, they certainly didn't say so. In fact, the Constitution itself, in the Fifth Amendment, explicitly mentions capital punishment, referencing being deprived of life with due process. Now, that textual recognition strongly suggests the framers explicitly accepted capital punishment, which I think undermines your argument that judges can impose categorical bans merely based on their assessment of fluctuating contemporary standards.
That textual point is compelling, I grant you. But it forces the entire constitutional analysis back to a very narrow focus on method. If we limit the Eighth Amendment only to the method of punishment, say execution by firing squad versus lethal injection, we ignore the crucial element of severity. We ignore whether the punishment itself is fair, proportionate, and aligned with the actual offense.
Okay, if your concern is proportionality, then let's look closely at the tool the court invented to enforce it. That three-pronged proportionality test that came out of cases like Weems v. United States. I argue this test is institutionally flawed and, frankly, dangerous because it requires judges to engage in policymaking, not constitutional law. To apply it, courts have to compare the gravity of the crime, compare sentences in the same jurisdiction, and then compare sentences across different jurisdictions. I'm sorry, but judges are simply not equipped to do this. They are required to, as it's been put, digest a vast amount of penological and sociological data not usually available to the jurist. This inevitably risks substituting the subjective judgment of a single judge or a panel of judges for the deliberative policy choices made by elected lawmakers.
I fully agree that the cross-jurisdictional comparison part of that test, the third prong, is administratively difficult for judges. That is a legitimate structural limitation, sure. However, that limitation doesn't invalidate the necessity of the principle itself. Proportionality is a foundational concept. It's necessary to prevent constitutional absurdity. Even before it was fully formalized, jurists acknowledged its necessity. Consider Justice Field's dissent in O'Neill v. Vermont. A sentence of over 54 years for illegal liquor sales was justly termed unusual and cruel when compared to the penalties for burglary or even manslaughter at the time. When a sentence is grossly excessive, when the punishment simply doesn't fit the crime, judicial intervention is necessary. If the Eighth Amendment is to have any constitutional force today, beyond just policing whether we use, a new needle or an old rope, proportionality must be mandated to assess severity relative to the crime.
You frame this as a judicial duty to prevent absurdity, but I frame it as judicial intrusion into the democratic sphere. The legislative branch, the representatives of the people are, as the courts themselves have acknowledged, patently better equipped than any court to assess community standards, gauge the seriousness of crimes, and determine appropriate deterrence. They hold public hearings, they study crime statistics, they respond to public safety needs. As Mr. Justice Stewart once pointed out, a heavy burden rests on those who would attack the judgment of the representatives of the people. When the judiciary shifts to using nebulous, evolving standards, it opens the door to policymaking and, I believe, violates core principles of separation of powers and federalism. And this leads to genuinely inconsistent outcomes, where the court might try to impose a national standard for punishment constitutionality, yet in other contexts, like, say, obscenity law, they require local community standards to apply. I find that contradiction difficult to defend.
That's a powerful defense of legislative primacy, but I would argue that focusing solely on the capacity of the legislature causes us to ignore the core constraint on state power, which must be judicially enforced. The judiciary cannot simply abdicate its role to define constitutional limits. Furthermore, the evolving standards of decency test is far from just a judicial whim. The Supreme Court established a pretty rigorous two-step method. First, the court looks for objective indicia, meaning legislative consensus across states, jury behavior, sentencing practices, to see if a new standard has already emerged democratically. Only after establishing that objective consensus does the court apply its independent judgment. This methodical approach has successfully established crucial limitations. We see this powerfully in the juvenile sentencing cases, like Roper v. Simmons, which ban the execution of individuals who committed crimes as juveniles.
But those limitations are built on sand if they aren't grounded in the original meaning of the Constitution. You mentioned Roper v. Simmons and the subsequent juvenile life without parole cases, Graham and Miller. Those decisions relied heavily on external sources, developmental science, neurological evidence, to argue that adolescents are less culpable and have greater capacity for reform. Now, while that might be compelling socially, that is policy analysis masquerading as constitutional interpretation. The moment the court starts relying on external, changeable scientific consensus to define constitutional limits, it trespasses into the legislative domain. The science might shift, or a future court grounded in originalism may simply declare that such scientific evidence is irrelevant to the 1791 meaning of the Eighth Amendment.
But that science is now part of our maturing standards of decency. Our understanding of human development has progressed radically since 1791. To ignore the fact that the adolescent brain is fundamentally different from the adult brain, especially concerning things like impulse control and risk assessment, would be willfully blind. The court established the framework requiring individualized sentencing for youth not just because of some moral preference, but because it aligned with a powerful scientific consensus demonstrating that most juvenile offending is the product of, transient immaturity, not irretrievable depravity. Overturning that framework would ignore decades of precedent that requires the courts to acknowledge differences in culpability based on development.
You're making a powerful argument for legislative reform, perhaps, but not necessarily for constitutional fiat. And the vulnerability of this entire framework is, I think, the most critical issue right now. The current trend on the Supreme Court shows a clear movement toward originalism, evidenced by cases like Bucklew versus Precythe, where the majority reasserted that the constitutionality of capital punishment is settled by the text and its historical understanding. This shift puts what you call more than 50 years of case law, built on the evolving standards of decency, on genuinely shaky ground. The justices most committed to originalism believe the Eighth Amendment should only bar methods of punishment akin to torture, the rack, the stake, drawing, and quartering.
The practical consequences of that belief are catastrophic. We are talking about dismantling the Miller and Graham framework, which currently protects thousands of individuals who are sentenced as children. While the originalist overlay is present, the logic underpinning the juvenile sentencing framework is profoundly robust and I'd argue widely accepted. The requirement that LWOP for juveniles must be uncommon and reserved for the rare juvenile offender is tied to a developmental understanding that provides a clear constitutional line. To suddenly declare that the Constitution ignores the developmental differences of children would require a severe and frankly painful disregard for precedent, for stare decisis. If the court overturns those rules, they are sending a message that modern scientific reality holds no weight against a static 18th century interpretation, risking a return to grossly excessive sentences.
Respect for precedent is important, yes, but we know that stare decisis is at its weakest when the court interprets the Constitution itself. The mechanism for dismantling it would be straightforward. A court committed to originalism would simply declare that the prohibition on cruel and unusual punishments did not historically encompass the duration or severity of a sentence, only the mode. Once the proportionality principle is severed from the Eighth Amendment, all categorical rules based on proportionality, including those favoring juveniles, become policy choices for the legislature, not constitutional requirements for the judiciary. This would restore judicial deference and respect for the political branches, regardless of how painful the individual sentences might feel to a judge.
Ultimately, the Eighth Amendment's power lies precisely in its capacity to adapt to our maturing understanding of humanity, criminal culpability, and, social progress. The developmentally based rulings restricting severe sentences for juveniles are the modern proof that evolving standards are not just an option, but a vital necessity to ensure proportionality and guard against punishments that truly shock the conscience of a modern citizenry. If we confine the Eighth Amendment solely to methods permissible in 1791, we forfeit our constitutional capacity for moral progress and fail to recognize the constitutional commitment to human dignity.
And yet, judicial restraint remains the most significant consideration here. The federal judiciary's responsibility in this realm is limited, and judges must avoid importing their own penological policy preferences into constitutional interpretation. Given the institutional limits on judicial fact-finding and the heavy presumption of validity due to legislative judgment, adherence to the original focus on the barbarity of the punishment method is, I believe, the only principled way to uphold principles of federalism and separation of powers.
The challenge certainly endures in defining that line.
Indeed. The fundamental disagreement really is where the court's constitutional duty to interpret a phrase as broad as cruel and unusual ends, and where policy-driven judicial overreach begins.